Let's kick things off with a simple question that might just change how you look at your daily interactions. Is lending a pen to a friend a legally binding contract? I mean, think about it for a second. You hand it over, they use it to jot down a number, and they hand it back. Super simple, right? But from a legal perspective, there's actually a whole lot more going on beneath the surface of that tiny everyday transaction.
Welcome to this explainer on the Indian Contract Act of 1872. Today, we're going to discover that you're entering into legal contracts all the time without even realizing it. Specifically, we're going to peel back the curtain on a hidden area of the law that governs almost every single time you hand your property over to someone else. In the legal world, this concept is known as bailment.
It's really fascinating to look at the origins of the word bailment. It actually comes from the old French word bailir, which literally translates to deliver, and that perfectly captures the essence of just handing something over. Under Section 148 of the Act, bailment is formally defined as the delivery of goods by one person to another for a specific purpose. And here's the kicker. It operates on an underlying contract that the goods shall, once that purpose is accomplished, be returned or disposed of exactly according to the directions of the person who delivered them.
So, here is our roadmap for today. We're going to break this down into 6 parts. What bailment is, the core elements that make it up, the types of contracts, the duties of both parties, the rights and terminations, and lastly, the fascinating rules around finding lost goods.
Starting with Part 1. What is bailment? The parties involved. To really grasp this law, we need to establish a shared vocabulary. You obviously can't have a contract without parties, and in bailment, they have very specific names. There's a clear dichotomy here. You have the bailor, that's the person giving the item, and the person receiving it, the bailee. It's really that straightforward. If you drop your car off at the workshop, you are the bailor, and the mechanic is the bailee. Handing a piece of cloth to a tailor to be stitched into a suit, you're the bailor, the tailor is the bailee. Honestly, even just giving a friend a book to read legally makes you a bailor.
Moving on to Part 2, Essential Core Elements, the Anatomy of the Law.
To understand exactly how this relationship is formed, you need 4 essential ingredients. Without all 4 of these, you do not have a valid bailment. First up, there has to be a contract. Now, this doesn't mean a signed piece of paper. It can be entirely implied just by the act of handing something over. Second, the goods must be delivered. This can be actual, like physically handing someone your laptop, or constructive, like tossing someone your car keys so they can get in. Third, there needs to be a specific purpose. You aren't just giving the thing away forever. And fourth, the exact goods must be returned. The critical thing to remember here is that possession changes, but ownership absolutely does not.
But watch out for this, because there's a really surprising legal exception. Putting money in a bank isn't a bailment. Why? Because you don't get the identical specific currency notes back from the teller. When you deposit a 100-rupee note, the bank doesn't put a sticky note on that specific bill and wait to hand that exact piece of paper back to you later. They just owe you the value. Because you aren't getting the exact goods returned, it fails step 4 of our requirements. Oh, and keeping ornaments in a bank locker where you hold the key? Also not a bailment, because you never actually transferred legal possession over to the bank in the first place.
All right, Part 3. Types of bailment contracts. The money factor.
Let's explore how money changes the legal dynamics of these daily agreements. Whether cash is exchanging hands or not drastically alters your responsibilities. We can break this down into 2 categories: gratuitous and non-gratuitous. Gratuitous means completely free of charge. You lend a bicycle to a friend, no money is involved, a free favor. Non-gratuitous, however, means both parties are getting some sort of benefit, usually a service for money. Think about dropping your watch off at a repair shop. You get a working watch, they get paid. And as we'll see in just a moment, the law treats these 2 scenarios very differently when things inevitably go wrong.
Which brings us to Part 4, Duties of the Bailor versus the Bailee. Let's map out the legal obligations.
Let's dive into the duties each party owes to the other once this contract is activated. If you're the person handing over the item, the bailor, you have some serious responsibilities, especially when it comes to expenses. For instance, if you lend your car for free and the engine fails completely through no fault of the driver, you must bear that extraordinary expense. You also have to disclose any faults you know about beforehand, and you absolutely must accept the goods back when the job is done. You can't just leave your car at the mechanic's garage for a month and treat it like free storage.
There's this vivid, almost funny example from the source material known as the vicious horse rule, and it perfectly highlights why disclosing known faults is so legally crucial. If you lend a horse to a friend for a ride, and you know that horse is vicious and likes to throw riders, you are legally required to warn them. If you stay quiet, the horse bolts, and your friend gets hurt, the law says you are responsible for the damages because you exposed the bailee to an extraordinary risk without a heads up.
On the flip side, if you're the one receiving the goods, the bailee, you have to treat them like your own. The law expects you to exercise what it calls ordinary prudence, so no unauthorized use. If you hire a horse expressly to ride to Varanasi, but you decide to take a fun detour to Cuttack and the horse gets injured, you're paying for that horse because that was completely unauthorized. You also can't mix the bailer's goods with your own without permission. If you mix your friend's really expensive flour with your cheap flour, you have to compensate them for ruining the batch.
There's also this fascinating rule about accretions, which is basically just a fancy word for profits gained from the bailed property. Section 163 is crystal clear on this. If you leave your cow in the custody of a farmer and that cow happens to give birth to a calf while you're away, the farmer cannot keep the calf. Any natural increase, profit, or accretion belongs solely to the bailor. Both the cow and the new calf must be returned.
Moving to Part 5, Rights and Ending Contracts, taking a look at terminations and remedies.
So what happens when things go wrong? Well, your rights totally depend on your role in the transaction. As a bailer, if you lend your friend your laptop and you catch them using it as a cutting board in the kitchen, which is a heavily inconsistent use, you can terminate the contract right then and there. Actually, if you lend it to them for free, you can demand it back at any time regardless. Meanwhile, the bailee has the right to demand indemnity if they suffer a loss just because the bailor didn't actually own the goods they handed over. And importantly, both parties have the legal right to sue any third party who damages the goods during the bailment.
Just like there are clear steps to create the contract, there are 4 specific legal triggers that officially terminate the relationship. The agreement naturally ends when the agreed-upon time expires or when the purpose is finally fulfilled, like when you return the catering tents the day after a wedding. It terminates if the bailor issues a notice due to misuse. And interestingly enough, if it's a free, gratuitous bailment, the contract instantly terminates upon the death of either the bailor or the bailee.
And finally, Part 6, the finder of lost goods. Is it really finders keepers?
Let's look at an everyday scenario that happens all the time. What happens when you find something that isn't yours? Does the playground rule of finders keepers hold up in court? Spoiler alert, it really doesn't. The moment you pick up a lost watch or wallet on the street, you are instantly bound to a contract of bailment under Section 168. You literally become a bailee, and the true owner becomes your bailor. You're now legally obligated to take reasonable care of the item and try to find the owner. Now, you can't sue the owner for the time and trouble you took to locate them, but you do have a powerful right. You can legally retain possession of the goods until they compensate you for any specific expenses you incurred while keeping the item safe.
I want to leave you with this provocative legal dilemma. If you find a lost item with a promised reward, can you legally hold it hostage until you get paid? The answer is yes. You actually can retain the goods until that specific reward is paid out, which just goes to show how powerful these everyday hidden contracts really are. Section 168 explicitly states that if the owner offered a specific reward for the lost goods, the finder may sue for that reward and can hold on to the goods until they get it. So the next time you lend a pen, borrow a bicycle, or pick up a lost phone on the sidewalk, just remember, you aren't simply doing a favor. You are stepping right into the Indian Contract Act of 1872. Which really makes you wonder, if simple everyday favors are bound by strict centuries-old laws, what other invisible legal webs are you tangled up in right now without even knowing it?